Father, thank you for this day. Thank you for the rain that you have brought. You know how much we need, not us. So send whatever it is that you want our way. Thank you for all the blessings. Thank you for the opportunity to come here to Atlanta and work with great folks with good hearts, trying to do the best we can for constituents back home. Bless all those that are less fortunate. Please always keep the first responders front and center in our prayers and thoughts as they take care of us in our most urgent times. In Christ's name, amen.
Thank you. If you want to be heard on one of the bills, please come up here and sign up on one of the sign-up sheets. If there's no one else, we will go ahead and collect the sheets, and we will start on the agenda with Senate Bill 182. This was a holdover from here, the last hearing, the one before that, I can't remember now, the last hearing. Senator Halpern, if you want to come back up, we have another substitute that you are working off of, and I show LC 491771S. Is that correct? All right. The floor is yours.
Thank you. I am glad to be in front of you once again today, along with Sam Owens. And what we did, if you'll recall, we were here last week, and there were some questions.
Well, if we can please hold the conversations down in the audience while the witness testify. If you need to have a conversation, please step outside. All right, go ahead.
Thank you. So we went back to the drawing board a little bit after listening to some of the comments from last week's committee meeting, and wanted to put forward a new sub that would tighten up some of the definitions. That was a big question. That would make sure that we align the definition of stalking with the language that's already existing in the code. And I mean, that's really it. We've tightened it up. We've still in this bill, and I can walk you through some specific changes, but we have still in this bill provided for both a civil and criminal path of recourse for victims of doxing. I can back all the way up and just remind you that doxing is when somebody takes your personally identifying information and with intent puts it out into the world, with the end result being harm to the victim, whether that's intimidation, harassment, threats. And so we can go kind of section by section if you want me to just talk through the changes from last week. But right in section 1, line 12, we have further defined close relation. We have on line 16, described mental anguish. Moving on to line 19, again, personally identifiable information. And again, as a reminder, this can be information that is publicly available, but again, in order to be accused of doxing, it is with intention that you release this information. Line 33, significant economic injury. These are the things that we had talked about as a group last time. And so we've put them in here with specific definitions so that there's no question whether or not a person would fall, into this category. We have, last week when you talked to us, PAC presented as well as GACTL. And all of the parties have worked together over the last week in order to come to some agreement around the language here. And so I feel so good about the fact that we've got multiple parties that have sat at the table who all recognize the importance of us actually defining doxing and providing recourse to the victims of it in a way that satisfies defense lawyers as well as prosecuting attorneys, and of course the victims themselves, which have to remain front and center in this conversation.
All right. Does anybody have any questions for the author or Mr. Owens about the new substitute or about the bill in general from the committee? All right, thank you. There's two others signed to speak. We'll let come up really quickly, and then we'll let you close out if necessary. Ms. Maisie Lynn Girton with GACTL. Thank you for working with the author on the bill.
Certainly, and that's just what I wanted to say. Thank you for giving us that time to do that. We never enjoy expanding the criminal code in my section of town, but believe that we've come together, and this is the most narrowly tailored option for addressing and redressing the concerns that Senator Halpern has in bringing the bill. So appreciate the time to do that.
All right, thank you. Any questions for Ms. Gerton? All right, thank you. Next, Taylor Hawkins with Frontline Policy. Good afternoon or evening. Evening.
Good evening, Mr. Chairman and members of the committee. Taylor Hawkins with Frontline Policy Council. We just wanted to take the opportunity to reinforce our support of this piece of legislation, put a letter in your folders last time this was heard, and I wanted to emphasize the impact on families that doxing has. 1 in 5 of those victims of doxing end up with a significant life change as a result of that, whether that is a job change, a home change. We're talking about something with serious damaging implications. And so the impact of the families is something that our organization has tried to highlight. And so we so appreciate the work of Senator Halpern on this bill and would urge the committee to pass this piece of legislation.
Thank you, Mr. Hawkins. Any questions for him from the committee? All right, thank you.
Thank you, Mr. Chairman.
And last on the list, Robert Smith with the Prosecuting Attorney's Council. Good evening.
Good evening. Going to continue the theme. Good bill. Appreciate the hard work from working with Senator Halpern, Charlotte Jackson, who was here last time, who's our family violence prosecutor. Thumbs up on the bill.
All right. Any questions for Mr. Smith? All right. You have Senator Rhett. Are you Mike 6?
Where do you buy your ties from, sir?
All sorts of places. I think this was a gift from a judge from when I left my last job. I think they got it from a department store.
There are some associations around here that give ties as gifts to members of the General Assembly.
One day, if I can earn there, I might be able to get a tie. Thank you.
Another serious question, Senator Cowsert.
Thank you, Mr. Chairman. I don't know if this is really your end of things, but I'm interested to know about this Section 2 creating a private cause of action for this. I don't ordinarily see that appear in criminal statutes. Or do you have a thought as to where that came from or what that's all about? Section 2, line 83.
She's got the best version.
I cannot speak to the origin of where it came from, and I know that in other contexts, there have been instances to allow injunctive relief to be filed on behalf of victims, and so it's not out of the ordinary, but I am unable to answer your question beyond that.
Okay, thank you.
Speaking of that one, maybe it's a question for Legislative Council. Because it says a cause of action for actual damages sustained, is it, and maybe a question, Mr. Olins, is it the intent and is it going to be in practice that someone would be able to seek a TRO or some sort of civil order in addition to damages to stop someone? Because I know that was one of the things we discussed, how slow a criminal case may go about, but someone may need to seek a civil remedy to immediately address something that's been released.
So when we talked with Charlotte Jackson about this after the last hearing, she assured us that they're already in the law were provisions to handle with TROs when necessary, and that it would simply be redundant in this bill, and that's why that section was removed for today's hearing.
Well, that was the temporary protective order stalking, or I know currently you have to go into the stalking, but I'm talking about from a civil standpoint, not a protective order from a family violence
From
type
a
protective
civil.
order, but from say you release personal information to mine, you refuse to take it down. If I were to sue civilly based on how this is written, is it the intent that I would not just be able to seek damages, but also be able to seek some sort of equitable relief that would require you to take that down?
So I would tell you, Chairman, as someone who had a stalker, there already are provisions in the law to deal with that because we, in fact, had those orders issued.
Well, for stalking, but what if it's not deemed to be stalking? Because one of the elements of stalking, I believe, is repeated acts. So if it's a one-time thing where I release information that's private information, I refuse to take it down, do you know if there's any other remedy?
No, sir.
Okay. And I don't know if Michael, did you work on this one, Michael?
I'm really kind of going on the fly, Mr. Chairman. I do see where there is, I really shouldn't speak. I'm not, I just
Okay.
I don't have a cogent answer for you.
And maybe, I know you can seek actual damages, and I would assume if I was reading this for a client that you could seek equitable relief as well in that kind of case. Maybe that's something we can look at moving forward.
Mr. Chairman.
Yes, sir.
This may be an answer for you. There is a provision in Title 17 that would allow a superior court, upon application by a prosecuting attorney, to issue a temporary restraining order prohibiting behavior that's considered harassing, and there is a defined term of harassment in this code section.
Okay.
For anyone's reference, it'd be code section 17-17-16.
Okay. Question from Senator Kennedy?
Yes, sir. Thank you, Mr. Chairman. Kind of following up on Chairman Calsert's question and Chairman Strickland's, the Section 2 that creates this cause of action makes me wonder what would be the interplay, if any, between restitution that could be, or could restitution be allowed, and if so, how does that impact a victim's ability to bring a cause of action, as we see starting with line 83, and how does that unfold, if you will?
Well, restitution is a constitutional right from the Marcy's Law that was passed several years ago, and also codified in the Crime Victims Bill of Rights. So if there is a demand for, or a need for restitution from a victim, they can always ask for it. And they can either ask for it inside the criminal case, basically after a conviction, they provided information to the prosecutor and said, hey, this is the restitution I need. And then we can ask for that on behalf of the victim, and it's made part of the criminal sentence. They have to pay a certain amount of restitution. Or they can choose to use the civil process, and with a criminal conviction in hand, go to a civil lawyer and say, hey, I was harmed by this person. Is there a cause of action I can make using this criminal conviction?
So you would view it as it would be the victim's choice as to which path they went?
Yes.
Okay. Thank you.
Any other questions from the committee? All right. Thank you both.
Thank you.
That's everyone that signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Parent by committee substitute LC 491771S, and a second by Senator Rhett. Any discussion? Senator Calzert?
I'd like to propose an amendment to delete Section 2, lines 83 through 89. I think this is redundant. I think it's implicit in any criminal offense that's intentional conduct. For example, on battery, assault and battery, we don't have a subsection of the code section providing a private cause of action. As the gentleman's explained, we already have injunctive relief. We already have restitution that's built into Marcy's Law and other sections of the code. You know, I think we'll end up starting to do this on every single criminal action, and it's a little bit unprecedented that you be able to get your attorney's fees in trial and appellate courts, cost of investigation and litigation reasonably. I think you're going pretty far afield, and I don't think that's needed to accomplish the purpose of this very good statute. So I would propose an amendment to delete Section 2.
All right, we have a proposal for an amendment to delete Section 2. Do we have a second for the amendment? Second from Senator Hodges. Do you want to be heard on the amendment? All right. We have an amendment on the floor to strike Section 2 that's been seconded. All those in favor of the amendment, please raise your hand. I'm sorry. Do you have a question?
Yes.
Let me have her ask the question. Do you want to ask it to Senator Calzert?
No, I wanted to ask it to the author.
Okay, let's do that. We'll go back to the vote.
Thank you. Appreciate it. Thought it would be appropriate to hear what they had to say. The question is, how do you feel about the amendment?
I am fine with the amendment. I think this is new language that we added in, and so it's fine. I mean, for the purposes of the bill, we want people to have recourse, and if they've got recourse and they're able to get restitution, if it's implicit, then I am fine with the amendment as stated by Chairman Calzert.
Thank you.
All right. So we'll go back to the amendment, which would strike Section 2 from the bill. All those in favor of the amendment, please raise your hand. And it is unanimous. All right, back to the underlying motion to pass. Wait, we have Ledge Counsel. Yes.
Apologize, Mr. Chairman.
No, you always should jump in.
If I could make conforming changes, there would be several other changes that would need to be made in the bill simply to accomplish deleting Section 2, nothing
Right.
substantive.
Hey,
I'd be
Les,
happy to describe them at your pleasure.
is there any objection from the committee for Mr. Walker the authority to make the other amendments that will be consistent with the striking of Section 2? All right. Thank you. All right, back to your underlying motion to pass by committee substitute now as amended. All those in favor, please raise your hand. It is unanimous.
Thank you. Thank you
Thank
very
you.
much.
All right, going to the next bill on the agenda, Senate Bill 421. Chairman Dixon. Good evening.
Good evening.
We are working off, give us 1 second, LC 394197S. Is that the substitute you have?
That is correct.
Okay.
Yes, sir, Mr. Chairman.
All right, the floor is yours.
Thank you, Mr. Chairman. Committee members, I bring SB 421 before you. It's an anti-swatting legislation. This bill makes several changes to the Senate structure for this criminal offense. Under the bill, the first conviction is treated as a misdemeanor of high and aggravated nature. But if the first conviction would become a felony if the response is to an unlawful request for emergency assistance to a dwelling, or if the response results in serious bodily injury or death. That felony, the first felony, would be punishable for 1 year to 10 years in prison and a $5,000 fine. The second conviction would move that up to 5-year minimum sentence, up to 10 years with a $5,000 fine. The third conviction would be a minimum 10-year sentence, up to 15 years with a $25,000 minimum fine. Also, in current law, and this would not change, if the first offense is to something considered critical infrastructure, like a government building or a school, that would be a felony on the first conviction with a minimum 5 to 10 year sentence and a $100,000 fine. This law also currently it's up to a judge. They could apply restitution for property damage. This bill would make that a requirement. And this bill is very important to me. My family and I got swatted twice. First time was on Christmas Day and then the day after. But luckily for me and my family, we knew most of the SWAT officers that responded to the house, and because of a Ring doorbell, I met them at the front door. Had I not known the officers, or had they not known me and I had not met them timely at the front door and they came in using force, you can imagine that can turn very dangerous or deadly quickly. And it's a bipartisan bill. 3 other senators were swatted around that same time, along with other elected officials. Kim Jackson was at home, her and her wife, with their 3-year-old son. It was the first Christmas with him. Unfortunately, it's very traumatic for them. And Senator Albers and also Kay Kirkpatrick, Senator Kay Kirkpatrick, was also swatted. Be happy to answer any questions.
All right, any questions for the author? Senator Hatchett.
Just at the appropriate time.
Well, it's not quite the appropriate time. You're supposed to make it more difficult when people come in front of Judiciary. We do have one person signed up to speak on the bill. Sam Owens, if you want to come on up, you can sit tight.
Okay.
He appears to be friendly to you.
Yes, sir, he is.
I try and be friendly to everyone.
Well, you never know.
Thank you. And I have one proposed change, and I mentioned it to Senator Dixon about a week or 10 days ago, and clearly we greatly appreciate Senator Dixon's leadership in taking on this issue. If you look at line 73, where it says assistance is a dwelling, emergency assisting is a dwelling, we would recommend adding 4 words or place of worship, because churches, mosques, synagogues are similarly running into this issue where people are calling 911, declaring that there's a state of emergency there, just like a home. And it just seems to me that that same protection that relates to our homes is unfortunately necessary with regard to places of worship. So that would simply be or place of worship after the word dwelling.
Or do you have any comments, Chairman?
No, I don't have an issue with that addition as long as it's the will of the committee.
All right, we have any questions for Mr. Olens? All right, no one else has signed up to speak on the bill. Senator Hatchett, what's the pleasure of the committee? We have a motion to pass by committee substitute. Well, we got to do our motion first. I know you've never chaired a committee before, Senator Watson, but you'll learn. We have a second from Senator Cowser by committee substitute LC 394197S. Now, Mr. Chairman Watson, do you have an amendment you want to offer?
I did, whatever.
Whatever Sam said. So the amendment will be on line 73 after the word dwelling, adding or places of worship, or place is a place of worship. Place of worship.
Yes, sir. Thank you,
Try to get
Senator.
our grammar right. Do we have a second? Second from Senator Redd. All those in favor of the amendment, please say aye. Aye. Any opposed? All right, back to the underlying motion to pass by committee substitute as amended. All those in favor, please raise your hand. It is unanimous. Thank you.
Mr.
Appreciate your
Chairman.
work on this.
Thank you.
Thank you.
All right, staying on the agenda, we are at Senate Bill 407. Senator James, if you want to come on up.
You're gonna roll it to the, you don't have to get in there yet.
Thank you very much. Mr. Chairman, members, thank you for hearing this very important bill. Let me, do you have, can you pass?
We're working off of LC 560038. Is that correct?
Correct.
All right.
About 2 months ago, my sister called me and said that she had just gotten home from the hospital seeing her husband who was in there, and the daughter, Rayshawn Danielle Hurd, had been visiting him, and he had fallen. He had playing basketball with the teenagers, old as me. But anyway, he was in the hospital, and she was praying with him, and she kept worrying because she had called 9 times on this guy who she was 4 months pregnant by, and she had been dating for a whole year, and he had beat her many times, and she called the police on him. But nobody ever locked him up, and they said, well, he has to do this, that, or the other, before we can do anything. And then 2 of the times when she showed very visible bruises, he was gone already. So they couldn't find him, and they didn't try. So after doing some studying and finding out what we could do here in the state of Georgia, where police officers would know if someone has been called many times for domestic violence at that home or with that person's name, they already have been found guilty, that they would have, I guess this would just put in the system when they get pulled over or when they get a call about them, that this person has a record for that. And maybe now we can save some lives, because I know many, many horror stories about other people who have been either beat brutally or killed. I even had a sister that she went to heaven during COVID, but she was in the Army from coming straight out of high school. So the person she ended up marrying in the Army was beating her, and I didn't find out until they had been married 7 years, and she called me. She was sick in the hospital, and I went down to Savannah, and she had old scars of broken ribs and other problems. So this is not something that just happened every now and then. It's happening too much, because she even called the police, and they were in the Air Force. They called, the authorities on him many times, and he waited until he put her in that hospital with even more broken ribs before they would do anything. And he still got right out. It was a revolving door. So anyway, this bill would give them a little help if they're being victimized and they have taken out a what do you call it? No, not a warrant against them. Restraining order. She did have that as well. I passed her obituary around. I want you to know how beautiful, how brilliant this young woman was. And her life is gone now. And so that's my niece, and I'm hoping that we can do something to, I know we can't bring her back, but what we could do to hopefully save other lives.
All right, thank you, Senator James. Any questions for the author of the bill? All right, no one has signed up to speak on the bill. What's the pleasure of the committee? A motion to pass by Senator Rhett. Do we have a second? Second from Senator Jones. All those in favor of the motion, please raise your hand. It is unanimous.
Thank you very much.
Thank you for your work.
Thank you.
And she lobbies hard. She sits right behind me, as you know. So it's got other bills in the committee too. All right, we're going to change things up a little and skip over Senate Bill 427 and hold it to the end because the author's apparently writing the budget right now. And so I told him we'd come back to him. And we're going to go to Senate Bill 448. Senator Hatch, you can do it from there, or you can step down, whatever you're most comfortable with. All right, what's your mic number? 13. We're working off of LC 442650S, a little code revision bill.
Yeah, this is Senate Bill 448, and it is the annual code revision bill. This just deals with typos, grammatical errors, issues of that nature.
I said the wrong LC number. Do you have LC 394040?
That's right, 4040.
Okay. Thank you. Go ahead.
Just deals with typos, grammatical errors, and any numbering errors that were flagged. It's a pretty straightforward bill. We vote on it every year, and I know a lot of people are excited to see this one get through.
It'd be a great place to hide something, and you haven't talked about any of this bill, and it's how many? It is 45 pages long, so we'd have to just trust you, right?
That's right.
Okay. And no one signed up to speak on it. This is the place to hide something. Say it's code revision, and give it to Senator Hatchett, and he'll just
at the appropriate time, Mr. Chairman.
Yeah, it is the appropriate time.
Can I make a motion on one bill?
Yeah, I'll make a motion.
Motion to pass from Senator Watson, a second from Senator Rhett. Any discussion? All those in favor of the motion, please say aye.
Aye.
Any opposed? All right. We will go on to House Bill 404. Let the record reflect that we are hearing a House bill. And I know you guys have been really busy on your side. I just somehow caught you. I don't know why I was watching it. I was one of probably 5 people in the whole state, but I was watching y'all debate bills the other day, and you were talking about cornbread from the well.
Yes, sir. It's a heavy material coming your way. Just get ready. Bend your knees, folks.
Right. That's right. Did you bring in cornbred for the committee?
No, I should have. Actually,
that would have been good.
It would have been ready at 4. Now it's 5. Just
perfect.
Glad to be here. It would have been cold, I guess, best way to describe it.
That's right. So House Bill 404, we heard this bill last year. Is that correct?
That is correct. Same bill that we passed out of your committee last year.
So we had a committee substitute last year. You're bringing to us same bill, LC 500549S. Is that right?
That's correct. Yep. And I think there's a lot of folks here on this bill.
We do have a lot of people wanting to be heard on it, but if you could review it for us, even though we've heard it before.
Yep. I'll review it. It's really, really simple. It's basically does 3 things to the code. It adds fit for human habitation to a landlord's responsibility. It adds caps security deposits at 2 months rent. And then for the first time in Georgia law, it adds 3-day right to cure once the landlord tacks the notice on the door. The tenant has 3 business days to pay everything that they owe in arrears and be able to maintain presence on the property.
This is one of those bills where everybody I hear from on each side, nobody seems overly happy with it, but it's usually a pretty good sign.
Yeah, that's it. You know, the balance is tough. I mean, when we got rising rents, but we also have people that haven't been evicted, it's a really symbiotic relationship. I think you have to be real careful what you do in this space, and I think this is a measured step that addresses some issues I think that were brought to the forefront with dangerous dwellings and the AJC. It addresses some of those issues, but it doesn't go too far to rock the boat to have unintended consequences. So I do think it's a measured step, and I appreciate you guys hearing it today.
All right, do we have any questions from the committee for the author? Senator Kennedy.
Yeah. Thank you, Mr. Chairman. Thank you, Representative, for explaining this. Have there been any changes to this from what we heard last year?
No, sir. It's the same bill that was in rules.
Okay, great. If you would look at lines 14 and 15, what are we addressing with that? That's not one of the three things you identified, and I'm not saying you should have. I'm just wondering, why is that in there?
This was put in on the last bill. I'm trying to see. So I think it basically says if I'm renting a place and the landlord allows me to upgrade the refrigerator or upgrade the AC unit, which a lot of tenants do, especially ones that have been there for a long time. If the landlord consents to that, then it breaks down. Then at that point the landlord would be liable for the repair of it if he approves such installation.
Okay.
But I think all that language was in there.
Okay.
Last year.
Would we need to change the effective date to
yes,
July 1 of 24 on 166?
Yes, sir.
Yes. Good
Okay.
catch.
Thank you, Mr. Chairman. Sorry.
All right, thank you.
Thank you.
Senator Hatchett.
I have a question about the lines 27 and 28 dealing with the security deposit. I know some landlords will charge a pet deposit. Is that included, or is that something different? Is a pet deposit also a security deposit?
I wouldn't think so. I would think a pet would be probably a pet fee, a non-refundable type deal, and a security deposit. Obviously, if they leave your apartment or house in good shape, then they can get the security deposit.
Okay.
But I would say that obviously a fee would be different than the security deposit.
Okay. Thank you.
Any other questions from the committee? All right, thank you. There's a number of people signed up to speak on the bill. There's only 2 opposed, but there's 9 in favor. So what I'm going to do is start the clock for 15 minutes in favor of the bill, and we will have everyone speak until the time has expired. So we'll first call up Miss Elizabeth Appling, and you can sit back behind there if you don't mind.
I'm going to slide out.
Yep.
These ladies having their day in the sun.
Thank you, Mr. Chairman. My name is Elizabeth Apley. I'm an attorney and a policy advocate. I'm here representing Presbyterians for Better Georgia, Georgia Advancing Communities Together, Enterprise Community Partners, 9 to 5 Georgia, the Georgia Supportive Housing Association, and House ATL. And together with more than 45 organizations on the one sheet that you have, from the faith community, the health community, children's advocates, lawyers, realtors, the pediatricians, mental health advocates, and civil rights advocates, all supporting the legislation. It was, as the chairman said, a carefully crafted compromise that will help to move us forward in helping to keep Georgians safely, stably, and healthily housed. More than a third of Georgians rent their homes, and this is going to bring us in line with what has already long been the law in most other states, including our neighbors here in the Southeast. Housing is the foundation for children to grow and thrive, for adults to work and raise their families. And without safe, decent, affordable, healthy housing, the mental and physical health of children and adults are threatened. Children can't succeed in school and parents can't work. So I know I've shared with many of you that there was a 16-year study of the effect of eviction on pregnancy outcomes on Georgia women, showing an association with prematurity, low birth weight, and multi-generational adverse impacts associated with eviction. And national research shows that eviction filings alone are associated with these same adverse impacts. The group most likely to be evicted, this is national research, are babies and children under the age of 5, that cohort. And just having children in the home dramatically increases the risk of eviction to Georgia families. We're currently essentially the only state in the country without a warranty of habitability. Most states adopted this back in the 70s, and so what we have is that simple language that is in the unanimously passed, House-passed version that you have before you, that rental housing must be fit for human habitation. So it's going to begin to address the scourge of people living in properties that are unlivable because of rats and mold and sewage that spews and utilities that are not functional. 19% of Georgia children removed from their home and placed into foster care are attributed to inadequate housing. This is the third largest reason why we're removing children and placing them into foster care, and the experts tell us it is the biggest barrier to families being reunified. Section 3 adds cooling to the list of utilities that cannot be terminated while an eviction is in process. And so it doesn't require the landlord to provide it in the first instance, but you can't try to force someone out by cutting off their water, their heat, and now it would say include cooling if that were already provided. The cap on security deposits is very important. You have a letter before you from St. Vincent de Paul regarding their Motel to Home program. These are families that get stuck paying high rents in extended stay motels, but they can't scrape together the resources to pay those security deposits. And as the author said, this is about refundable deposits, not non-refundable fees. Most states limit security deposits. 13 states limited to 1 month, 3 states to 1.5 months, 12 states limited to 2 months, and only 1 state at 3 months, and that's only if the landlord and tenant agree. The written notice and 3 business day right to cure is a very important part of this bill in order to help landlords get paid, give tenants a few more days to pay the rent, and avoid burdening the court system with these eviction filings that generally don't result in evictions, but do end up with a record on these people's that is picked up in background checks by subsequent landlords and makes it virtually impossible for them to rent that next home. 40 other states, including Alabama, Louisiana, Mississippi, Florida, South Carolina, Tennessee, Virginia, and Texas, have long had this law on the books. So I'm hoping you're going to hear from my friends at the Apartment Association. You'll recall that both the Apartment Association and Realtors testified last year that they are neutral on the bill in its present form. We're not seeking further amendments, and we're asking for your support in passing the bill. And of course, I'm happy to answer any questions.
Thank you, Ms. Appling, and I want to thank you. I know we've met multiple times about this bill. You've got a lot of groups we're working with, and thank you for keeping everybody on the same page with trying to get a bill that, from your folks' perspective, does move the needle, even though there's been requested changes to go further. I appreciate the way you managed this. Any questions for Ms. Appling? All right, thank you. Next, we have Cole, and is it Thaler? Thaler. Good evening.
Good evening, Mr. Chairman, members of the committee. Thank you for this opportunity to speak. I am an attorney who for the last 10 years has been representing tenants living in poverty at the Atlanta Volunteer Lawyers Foundation, and for 4 years before that, representing rural tenants in poverty at the Georgia Legal Services Program. And my only point is that this bill will make a material difference for those most vulnerable tenants. The reason why people might move into a home that is not habitable is out of desperation. They're coming out of homelessness, they've been sleeping in tents or in their vehicles, they are fleeing violence, they are coming out of worse living situations, and they do not have the bargaining power to negotiate with the landlords to make repairs before they move in. They make the determination that a leaky roof is better than no roof at all. So I believe that we will see a material improvement in the circumstances for those vulnerable tenants if this bill were to pass. Thank you.
All right, thank you. Next we have, is it Jana Covington? Good evening.
Good evening. Hi. I'm Jana Covington with Georgians for a Healthy Future, and we wholeheartedly support the passage of 404 with no amendments. Our thought is that we see it as a healthcare bill. Housing is a basic necessity closely tied to a person's health. To live healthy lives, Georgians need stable, affordable, and healthy housing. And the amount or quality of health care a person receives is rarely going to make up for a lack of stable housing. We also did some research, and when people experience housing instability, they can suffer more from health conditions such as asthma, diabetes, and disabilities. School attendance, learning, and work attendance can be compromised by unhealthy housing situations. Housing stability, quality, safety, and affordability all affect health outcomes. Residential instability is associated with health problems among youth, including increased risks of teen pregnancy, early drug use, and depression. Providing access to stable housing can improve health and reduce health care costs, and therefore, again, we fully support passage of the bill without any amendments.
All right, thank you. Next we have Polly McKinney from Voices for Georgia Children. Good evening.
Good evening. Hi, everybody. In interest of time, I will reference a fact sheet about homelessness, and there's some good data in there that you can read at your leisure. And just to read, a lot of folks have already stolen my thunder, so I'm only going to say the new stuff. Elizabeth mentioned the foster care issue with kids who are in unsafe and unstable housing. It is, in fact, a real problem. And what I would say is that in FY23, over 38% of foster care placements cited inadequate housing as one reason. So the 20% is maybe the main reason, but there's another good 20% on top of that. That is a challenge. And like I said, everybody stole my thunder, but just for us, we're in complete support of this bill. And the fit for habitation is super important for pretty much absolutely everything that a kid needs. So with that, thank you. Happy to answer any questions.
All right, thank you. Don't have any questions. Next we have Beth Stevens, Enterprise, but I couldn't read the last part. Something partners.
Community partners.
Community partners.
Yes, thank you. Thank you, Chairman and members of the committee. My name is Beth Stevens. I'm the State and Local Policy Program Director for Enterprise Community Partners, and I'm here to share our support for House Bill 404. We have a Southeast office here in Georgia. We are a national affordable housing intermediary, providing capital, policy, and programs to support the preservation and development of affordable housing. We regularly work with owners and operators of affordable rental housing, and we understand the challenges that landlords face. We understand the critical role that rental housing providers play in our communities, and we appreciate the importance of a reliable stream of rental income for those housing providers. We also understand the importance of keeping Georgians safely and stably housed. Eviction can cause long-term financial instability, psychological strain, depression, family separation, child poverty. You've already heard that from other testimony you've received today. Eviction also harms housing providers. The search for new tenants can be lengthy and costly. Preventing and avoiding eviction benefits families, communities, society at large, and landlords. Enterprise has studied strategies to prevent eviction and promote housing stability, and several of our recommended strategies are in this legislation, including security deposit maximums and strengthening warranty of habitability laws, which are upstream interventions that can increase housing access for low-income households and create a minimum standard for the condition of rental housing. Establishing a right to cure period is something that 40 other states have already established. There's a flyer in front of you from Enterprise that highlights some of that data and information. Hopefully you have that. Regardless of the outcome, an eviction becomes part of a tenant's permanent record, even if the landlord and the tenant reach a settlement agreement or a case is dismissed. And these records can severely limit a tenant's ability to access future rental housing. Eviction can put families on a trajectory towards homelessness and increasingly poor housing conditions. Moving causes children to switch schools, or parents may lose proximity to a job. So House Bill 404 is a compromise piece of legislation that puts Georgia more in line with other states that have already passed these tenant protections. So for all those reasons, thank you for your consideration, and we support the bill.
Thank you, Ms. Stevens. We have 8 minutes left. We have 4 other speakers. John Moy with the Urban League. Good evening.
Good evening, Senator. How are you?
Good. About you?
Thank you all very, very much. I'm going to be very brief. I think really enough has been said in support. So, in short, this bill does 3 things that are very important for the Urban League. First of all, it certainly caps the security deposits at 2 months. It also requires landlords to provide tenants with written notice and a 3-day business day right to pay back due rent before the landlord can file for eviction, and a right to cure. We also know that that the greatest risk of evictions is for infants and toddlers under 5, and for kids of color and their mothers, it's almost 2 to 5 times more likely that they will be evicted. So I think we certainly join the list of organizations in support of this bill: Presbyterians for a Better Georgia, the United Way of Greater Atlanta, the NAACP Legal Defense Fund, and urge you all to pass this measure.
All right.
Thank you.
Is it Ayana Jones? Okay. With the Atlanta Volunteer Lawyers Fund?
Lawyers Foundation.
Lawyers Foundation. Well, it's close.
There's a lot of letters in there. Acronyms are also not my thing. So good afternoon, and thank you for the opportunity to testify on behalf of House Bill 404. My name is Ayana Jones, and I am the senior litigation attorney at Atlanta Volunteer Lawyers Foundation. Cole is actually one of the colleagues. I've been there for 7 years. Prior to that, I worked for 7 years with Georgia Legal Services, servicing the surrounding rural counties of Atlanta. So I have dealt quite a bit and been in court quite a bit regarding these issues. The first thing I want to bring the committee's attention to is that there are a high number of evictions just being filed. In 2019, before the COVID-19 global pandemic, the Fulton County Magistrate Court reported 45,000 eviction filings alone. In 2023, that number is reported as 38,000, and it's still going up. The problem with this is that it costs landlords, it costs tenants, it costs the court system, and it costs the community. And these are just the filings. My colleagues have already mentioned how the filing alone can be detrimental to tenants finding other housing. So this bill is really important because it does put in place some preventative measures. And first, the written demand notice. So before an eviction is filed, the opportunity is given for landlords and tenants to resolve that issue. It's very important to have that because there are resources in the community. There are resources among the tenants where they could potentially resolve the issue before it gets filed and it becomes public record, thus making it harder for tenants to find later housing because of tenant screening agencies. The second thing I want to mention is that I have been personally, I don't know if you've heard, Forest Cove has been a complex that has been a blight. Despite numerous code enforcement violations since 2017, when I started with AVLF, the property was allowed to continue to operate and to rent to tenants. So this habitability, this fit for human habitation, is incredibly important because it would have prevented an agency and the opportunity to continue to operate and rent housing that you wouldn't put your dog in. These housing conditions were horrible. Rodents, rats, mold, things that I have personally witnessed. Elderly people, disabled people, and school children having to live in these conditions because they could not be shut down because the landlord did not have to have any kind of warrant of habitability. And the third thing I'll talk about is the security cap. We all know that there is this opposition between rising rental rates, but the incomes of Atlantans are not matching that. And that means that finding a security deposit is incredibly hard because tenants are having to basically live paycheck to paycheck and still try to scrape up the money for security deposits. So this security cap is very important and will put us in line with, as my colleagues have mentioned, many, many other states. So it is for those reasons that I ask that this bill go forward. Thank you for your time.
All right, thank you. We have 4 minutes left. Is it Cy Moore with the New Georgia Project? Good evening.
Hello. Good afternoon. I'm Cy Moore. I'm lead affordable housing organizer with the New Georgia Action Project, and we have a base of over 2,000 base members. Last summer, my team and I, we conducted a statewide survey of over 500 Georgians, and we received an overwhelming response that issues that affect Georgians the most were high rents and tenants' rights. Through hundreds of one-on-one interviews that we conducted with these Georgians, 3 times the rent is a huge issue when pay isn't rising. High deposit fees, along with substandard maintenance and living due to corporate greed and slumlords. With unchecked power and zero accountability. If this legislation passes, we can inform our base and your constituency of who is for affordable housing and who is against it. So with that being said, we are in support of this bill, no changes.
All right. Thank you very much. And we have Callan Wells.
Mr. Chairman, she had to leave for childcare reasons, and Healthy Mothers, Healthy Babies also asked to express their support. Callan was here for years. Healthy Mothers, Healthy Babies.
Healthy Mothers, Healthy Babies, and Gears supports the legislation. All right. And then on the other sheet, we start with Jody Williams. All right. Well, that leaves Hayden Stanley. Come on up, Mr. Stanley. Close us out. All alone. It's a lonely place.
Thank you, Mr. Chairman. For my 15 minutes, I'd like to start. We got to go all the way back to the Magna Carta.
You got 2 minutes. Start the clock.
My name is Hayden Stanley. I represent the Georgia Apartment Association. Had the opportunity to speak last year, so I'll be much faster this time. The owners of properties, management companies, investors, producers of housing in Georgia who make up the Apartment Association, we're not asking you to amend this bill. We're not asking you to vote against this bill. But you've received a whole lot of information today, and they wanted me to pass a couple of things along to you for context. In Fulton County, there are, if you filed in August for someone who hasn't paid or someone who is who's criminally acting, or you discover that they have fraudulently obtained that property, and you filed for that that eviction in August of 23, you're in court this week. And then there's another 5 to 7 months before the Fulton County Marshal will act on it. There are currently 3,200 writs of execution sitting in the Fulton County Marshal's office. So a year and longer is sitting there. The units are held off the market. In many cases, folks that are occupying those units for those reasons I told you are not paying toward that, and that's creating an effective occupancy deficiency. In DeKalb County, credit to their court system, they've caught up. They're on a more regular basis, but they still have 2,600 writs waiting to be executed by their marshals, and that's months and months and months and months. So please keep in mind, Representative Carpenter, you've done a fantastic job. You have come up with a measured bill, and we appreciate all the time you've given us and what you've done here. But please remember, as we continue to come back on behalf of these property owners and these investors, there's a whole lot that needs to be done to take care of those. Georgia's no longer the golden child for investment and attracting people to come in and build here to provide the housing that we need. and there's a lot to address on that end. So thank you very much. I appreciate your time.
And as I told Ms. Appling, from a lot of folks on the other side of the bill, thank you for your work at the same thing. People wanted different changes, and I know you worked hard to get to thread the needle, have a bill that your folks could live with as well. So I appreciate how you handled all this through the last year or two.
Thank you, sir.
I have a question from Senator Calvert.
Thank you, Mr. Chairman. Stanley, prior to this bill, to your knowledge, has Georgia had a warranty of habitability either statutorily or through common law?
Yes, sir. In fact, 4472 sets up the framework for this, and it weaves in and out. It says any contract, lease, agreement, oral or written, for the use or rental of real property as a dwelling place, a landlord or a tenant may not waive or avoid any of the following duties, rights, and remedies. And under C, it references as defined by the ordinance, which local governments have the authority and the obligation to adopt and enforce, that dwelling is not unfit for human habitation. And we go through, there are a number of provisions in Georgia law. What Representative Carpenter has come up with here further strengthens that.
Thank you.
Thank you.
You have more questions, Senator Kennedy?
Thank you, Mr. Chairman. Thank you, Mr. Stanley, for being here. Just a couple of questions. One, you referenced the high dispossessory actions and that have had to have been filed and that are pending and how long it takes. Speak to us as to, from the business model, of how that impacts effectively the rental rates that are then charged within that complex or charged by that investor as those costs get involuntarily visited upon the property owner.
That's exactly what happens. And for a larger company with thousands of multifamily units, for example, that spread is going to be much broader, but it is going to increase. It's the same with healthcare, where people come into the hospital and some pay and others don't. We all pay more for that. It's the exact same result when it comes into owners of housing providing that housing without compensation, but the continued risk of what can happen from those residents or those tenants who are in there. That is going to increase everyone's cost. But then you move on to an owner who has a handful of houses that they rent, and we don't represent them, but they are not able to carry a note for a year without income and without rent being paid. So that's going to be sold off into either, everybody hates these institutional investors of single-family rentals. Well, that's where they're going to go if someone who's invested for their retirement is unable to reclaim that unit or that house.
Thank you. One more, Mr. Chairman, if I may. And we heard some testimony, or some comments rather, about the rising rent rates, and that's something that's concerning, but it's not something that we as the government controls. That's market driven. But I want you to speak to, if you can, you said that the concern about how Georgia is viewed by investors who will either come to Georgia and build the needed housing that we need, or buy and maintain and stay in the market for housing, so that people that need homes or apartments or need a roof over their head can actually have one on the market that's available. Speak to the long-term effect of what happens when investors start turning away and aren't willing to come to Georgia because of the environment that's here.
Well, thank you.
Excuse me, and specifically, that's too broad of a question. Speak to what that does for the availability of continued housing for people that truly need it. That's really the focus of the question.
It is, and it's a market. You want as much housing stock, quality housing stock, as you can produce, and that's generated by the environment where those investors and those risk takers are going to place their money and their resources and their and provide that housing. The great environment that we have in Georgia overall as the #1 state to do business we hear about, that's absolutely true, and it's fantastic. But Metro Atlanta is the epicenter of fraud, application fraud. One owner that several of you who rent while you're in town for the session, they estimate that 6 out of 10 of the applications for housing that they get are substantially fraudulent. And that means a stolen ID, a made-up ID, or just generation of income that's non-existent. So they're trying to fight and stop all of that, but still they make it through. So that's one thing that Georgia has, which is not a great mark. The other is, frankly, the lawsuit environment as it applies to premises liability, and that's a conversation for another day, and I hope we have it in this committee. But that is also well known. And then the third piece and the third threat to further production of housing in Georgia is this year-long effort it takes to get a property back for non-payment, for fraudulent activity, or for criminal activity. So all of this comes together in the long term is money's going to go elsewhere. And if it's not coming here, then we're not going to produce the housing that we need to keep up with the great economic development.
Thank you. Thank you, Mr. Chairman.
Senator Hodges.
Thank you, Mr. Chairman. Mr. Stanley, I should know this, but I don't. In the state of Georgia, if a tenant does not pay their rent and a landlord acts quickly to preserve their rights, absent a backup in the court system, just absent that, how long should it take to get your property back?
Each county and city are different. However, they all follow the same law. And I know that there are lawyers from the Atlanta Legal Aid Society who can speak to this chapter and verse. If you followed the law, it's going to be a month. If you follow the practicality pre-COVID times, pre-bottleneck and year-long backup, it's typically between 60 and 100 days.
Okay, I was inquiring about the fairness of the 2-month deposit. I understand what Mr. Carpenter's trying to do, as far as limiting the upfront cost of somebody trying to get housing. But I'm just trying to balance the fairness with who's providing it to.
Yes, sir.
Thank you.
Senator Redd or Jones, what do y'all have your butt? Senator Parent, sorry.
Thank you, Mr. Chairman. Thank you, Mr. Stanley. Just a couple of questions. So if the problem that you laid out with, the examples you used were Fulton and DeKalb, that doesn't really surprise me, is obviously these big urban counties are going to have more actions, and you can't really necessarily compare every community across Georgia the same way. But my question is, how would this bill affect that? It seems that that's already...
That's a most valid point. This bill, I do not believe, will affect that. What I wanted to do is take the opportunity as we talk about this side of the equation and point out that there are a number of issues that investors in property need support and help to address.
Okay, thank you for that clarification. The other question I had is, there was some discussion, and I think you kind of just referenced it again about, well, if the environment is unfavorable, money might go elsewhere, et cetera. But isn't it the case that, I guess I'm trying to square that with what you're saying is already a statutory plus court-ordered precedent of a warranty of habitability. Like, sort of the line I'm hearing is we already have that.
Yes. And I'm not talking about this bill passing, creating the flow of investment. I'm talking about the 3 issues of the fraud that happens in Metro Atlanta, the premises liability environment in Georgia, and the long backup through processing evictions.
Okay, but you're saying none of that relates.
I wasn't speaking to this bill as souring the investment mode.
Okay.
It is.
I guess I misunderstood your testimony because it seemed, okay. So this bill's fine. You're just concerned about future conversations.
We're not asking you to vote against this bill. And I was just kidding about 15 minutes.
Okay. Thank you, Hayden.
You met it.
Am I free?
You are free now. I'm
Thank
not going to
you
ask
very
if
much.
anybody else has questions. Thank you. Appreciate your work on this. All right, that's everyone that signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by committee substitute LC 500549S from Senator Rhett. Is there a second?
Second.
Second from Senator Parent. All those in favor?
We need an amendment for the effect.
We have someone who wants to offer. Thank you, Patrick.
Nice
An
work,
amendment on
Patrick.
line 66 to change 23 to 24 for the effective date. Senator Kennedy, do we have a second from Senator Hatchett? All those in favor, please say aye. Aye. It is unanimous. Back to the underlying motion to pass by committee substitute as amended. All those in favor, please raise your hand. It is unanimous.
Thank you, guys, and appreciate you going through this process with me.
Thank you. Appreciate your work. Yep. Now go over there and pass some more really important bills in the House.
Senate bill in my committee, it's going, it flies out of there like hot butter on cornbread. Appreciate you.
Yes. All right. Mr. Appropriations Chairman, if you'll step up here. Last bill on the agenda. Senate Bill 427. We have a motion to adjourn from Senator Kennedy. A second from Senator Cowser.
Vote on it. I might be okay with
Hey,
that.
Mr. Chairman, are you still a full leader for the governor? Is this a governor's bill?
Most of his are.
Yeah. Are you speechless?
I don't know if he would support it or not. I hope he would. But thank
Well,
you,
I
Mr.
guess
Chairman.
we'll find out in a few months.
We were floor
Maybe we'll
leaders
have
together.
good luck on this one.
We were floor leaders together back in the
We
day.
were. I was just reminiscing on good times.
I remember you got higher marks than I did.
Well, I'll stop while we're ahead. All right. We are working off LC 491659. Is that right?
It is.
All right. The floor is yours.
Thank you, Mr. Chairman. The Senate Bill 427 follows up on the Senate bill we passed last year concerning attorney advertising in its basic point. The bill we passed last year said four things. It's OCGA Code 10-1-4.2, 424.1, sorry. 10-1-424.1. And it said basically four things. If you were going to advertise as a law firm, you couldn't say you're a law firm if you weren't. You couldn't say that you were practicing in certain areas of law that you weren't. And you could not use a face that was not of your law firm. In other words, you couldn't hire someone famous to be there and not disclose that later on. And you could not, and you couldn't do, you could do all those things, but you had to disclose it later on. I guess that's the better way to say that. What this bill 427 comes back and does is it says, hey, that disclosure needs to be a certain size. I'm sure we sat through Super Bowl ads yesterday, and you probably noticed that when you get to certain disclaimers, folks can read really, really fast. They can make those disclaimers be the same color as the background so they blend away, and they can make them smaller font than normal. What 427 says is it looks at attorney advertising and says, no, if you have to use that disclosure, first of all, if you don't do any of those things before, you don't have to use the disclosure. But if you do have to use that disclosure, the disclosure shall be no less than 50% of the total visible space of the ad. That means if you're using a billboard, it's half. If you're using a TV screen, it's half. It should run for half of the ad if you're doing it as a TV or radio ad. And that it can't be read at a speed faster in words per minute than you did the rest of the ad. That's in lines 29 through 31. It also takes, while I was doing this, people kept asking why. I said, hey, listen, I think attorney advertising has perverted our system of justice. And many of you agree with me on that. I know we've talked offline. But I looked, and actually attorney advertising was the number 8 on the list of top 10 advertisers. 1 through 7 was pharmaceutical companies. So I started talking with my colleagues in other states about how they were handling that and what was going on. It was very interesting to me to see that certain advertising in the pharmaceutical respects had caused other states to move to take those drugs out of their state health benefit plan. The biggest ones being what I think they're called GLP-1s. I'm not a pharmacist. You would probably know them by names like Wegovy and Ozempic. They were driving up the cost of the state health benefit plans so much that North Carolina said, hey, listen, we're not going to cover those any longer. So if we're having this same issue on attorney advertising, which I do think we are, I think the same should apply in a pharmaceutical concept. construct. I keep saying the wrong word. I'm sorry. The thought there being these guys are already required to put disclaimers in their advertising, and I know that some folks have signed up to speak and say so. But they don't have the same restrictions that we have that we're placing on attorney advertising if we pass this bill about it being 50% of the ad, about it being read at the same speed as others, about it being visible in other times. I actually had one of our Senate colleagues today come to me who had signed onto the bill and said, hey, I was watching the Super Bowl ads last night. I think they may already be doing this. And if they are, that's great. That's good. We're just putting into code one thing that would help us balance back about what we're doing against attorney advertising. That's all this bill does in its simple form. Maybe it's able to make an impact. I personally think the hit and the aim at attorney advertising in this aspect is the second largest bill we have this year as far as countering some of the issues you heard Mr. Stanley mention earlier concerning torts. So thank you for your consideration. And Mr. Chairman, I'll yield the questions or yield the seat.
All right, do you have any questions for the author? Question from Senator Kennedy.
Thank you, Mr. Chairman. Thank you, Chairman Tillery. I want to make sure I understand this. So lines 39, well, beginning, I guess, with a quotation on line 40 through the end of line 42, that has to be printed or stated or audibly spoken in any drug ad? Is that what that's saying?
Yes, sir.
Okay. Did this language come from any other state or some model language? Is it used anywhere else?
No, sir. It was language that we wrote up, again, based on the budgetary things that we were looking at and fixing, or trying to fix. I did, well, sorry.
Well, I'm just wondering, in reading it says false or misleading advertising of drugs is illegal in Georgia. If a drug advertisement is false or misleading in any particular, the advertisement is considered to be completely false under Georgia law. I guess I'm wondering, what is the general public supposed to take from that information? That they go here with that, they report there, they take this action. That's what I'm trying to work through. I'm trying to think, what does the person sitting at home watching the television, and what triggers them to do something?
Take an action afterwards? Right.
Yeah. What is it that they took the drug and it didn't act as it was supposed to, or they think this? I'm just trying to follow the line of thought of what we're protecting and how the consumer, what actions they take so they get the protection you're trying to give them, which I think is good.
Would there be other language you think you would like to suggest?
No, I don't have any. Sorry, I've read this tonight for the first time, and I realize I'm being kind of vague. When I read that, I thought, well, what does this tell Joe Smith sitting at home?
Yes, sir. The response. I was speaking with the pharmaceutical lobbyist group reached out to me Friday. I thought we'd have some language, and we don't. Which I understand that they may oppose the bill. My suggestion would be if we could strike before the quotation and after the quotation and enter in the disclosure required by federal law, it'd be perfectly fine. And that's an easy floor amendment or easy committee amendment.
Okay.
So
do you know what that language says?
The pharmaceutical group that actually presented language, it would just be what they have to put already. Okay. They told me they're highly regulated and they have to write all these things in their ads. So I would just say, why would we not take and strike and say, literally strike after the colon and say, include within such advertisement. Instead of saying the following disclosure, just say within such advertisement, the disclosure required by federal law. The disclosures required by federal law. And then you can strike lines 41 and 42.
Chairman, I appreciate you trying to work with me. I don't know what that other says, and please understand, I like what you're trying to do. I like the disclosure. I don't have any good ideas on how to fix what I'm alluding to that may be a problem. I'm not even sure that it is a problem. So I don't know. Maybe you and I can work on this offline, and maybe a floor amendment. I don't want to slow this down is what I'm trying to tell you.
Thank you.
If there's a different time to try to look at doing something differently.
Yes, I'm happy to do that. I think the disclosure by federal law would probably make the bill better.
Well, I don't want to offer that or agree to it without seeing it, so, you know.
Understood.
Any other questions from the committee? Senator Hatchett?
Thank you, Mr. Chairman. I know we've talked about this some, but the code section, the 10-1-4.24, deals with false solicitation in media of legal services. So this disclosure and qualifying language would just be applicable if you're falsely advertising, or
if you're doing one of the three things that we put in code before, that's why you would have to use the disclosure, and that's what we passed last year.
what could you go back over the three things?
If you're, first of all, if you're not a law firm practicing law, I think that was going to get knocked out originally.
That makes sense.
If you say that you're practicing law or practicing certain areas of law and that you're not able to do, that would be area number 2. Area 3 is really where the disclosure comes in. It's when someone else is standing up there. We've seen these ads that I want to be careful not to single out or say, where someone is not of your law firm, someone is not your client, and they are able to do things that would create the perception to those watching that those were either members of your law firm or perhaps were able to make a recovery because of your actions and therefore would be your clients. That is where the disclosure language had to come in.
So if I can follow up, Mr. Chairman. So if just for example, Blake Tillery, attorney at law, wants to put up put an ad in the local football program or the local newspaper, or put your name on a billboard, just Blake Tillery, attorney at law, would there be a disclosure requirement there? Assuming you are a lawyer.
Right. I don't think there would be a
And you're a
disclosure.
celebrity, does that make a difference, you said too?
Thank you. I'm still a member of the firm, so I don't think that does. What would likely be a problem, and I'm going to be kind of funny as I say this, is if I were to take Bo Hatchett and his awesome picture from his days as the top swimmer at
That comes up
Georgia
a
Tech
lot in
University.
this committee, actually. Yeah.
At Georgia Tech Institute of Technology, and use him and say, dive into success with a Tillery law firm. I think then I would have to say, the firm is not affiliated with Georgia Tech, nor is Bo Hatchett a member of the firm or an attorney practicing at the firm or a client.
That makes sense. As long as you're advertising truthfully in what you do and your own clients and things of that nature, this disclosure would not be required.
I don't think it would be. And that's when we got into the discussion last year. I know it was a year and a half, maybe even ago, because it was early in the session, that we were talking about puffery and the difference when puffery led over to falsity.
Gotcha. Thank you.
Any other questions from the committee? Yes, sir. Mike 11. Senator Kennedy.
The 50% minimum requirement of the
Yes,
screen, so to speak, that we talked about in the lawyer ads, that same model applies to drug ads in
Yes, sir.
Georgia?
That in this bill. Yes, sir.
Have the drug companies talked to you about that? Have they said
They
what that?
have a letter in your folder, by the way.
Okay, sorry.
Yeah.
They have. I mean, I don't think they're any happier than the lawyers are about it.
Okay. Thank you.
Any other questions from the committee? No one else signed up to speak on the bill. What's the pleasure of the committee? Motion do pass from Dr. Watson. Do we have a second? Second from Senator Jones. I was getting nervous there for a second for you, Mr. Chairman. It's happened to me before too. I remember it very well. All those in favor of the motion, please raise your hand. It is unanimous. Thank you, Mr. Leader. With that, we are adjourned. Thank you.